You usually hear it here first at the Four Boxes Diner. And indeed, I'm going to be proven correct yet again. The Everytown for Gun Safety has filed a major brief on behalf of California in the May versus Bonta case, Reno May versus Bonta, which is the quote-unquote sensitive places case dealing with government-mandated gun-free zones. Everytown filed a powerful brief. If you assume, for the sake of argument, that the relevant time period for interpreting the Second Amendment is the late 19th century, despite the fact that the Second Amendment was adopted in the 18th century in the year of our Lord, 1791. Don't worry, folks, I predicted this over a year ago and blew this up before Everytown could even get into court with this argument. Stay tuned and let me explain why this powerful brief by the anti-gun lobby and Everytown for Gun Safety is simply not going to fly as a matter of constitutional law. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Stay tuned for a new book coming out in a month or two. We'll talk more about that in a bit. Okay, so the Everytown for Gun Safety, a very powerful pro-gun control organization. Talented lawyers, talented people over there, although I disagree with all their views when it comes to our right to keep and bear arms. I'm sure they disagree with mine. But Everytown is a formidable opponent in the fight over our Second Amendment rights, and they have talented people. So when they make an argument, you have to take it seriously, and the courts will, even though I think ultimately their arguments should fail as a matter of constitutional law. And that is the case with what was just filed by Everytown in the May versus Bonta case. Just to jog your memory, the Reno May versus Bonta case was the case where the federal district court judge basically declared and enjoined virtually all the quote-unquote sensitive places that the state of California had adopted and passed after the June 2022 decision in Bruin, expanding the scope. It didn't really expand the scope, it reaffirmed the scope of the right to keep and bear arms for people to carry guns outside the home for self-defense. And California and Gavin Newsom went out there and tried to declare everything under the sun to be a sensitive place, which is a euphemism for government-mandated gun-free zones, which, of course, as you know, is really just a killing zone unless you provide comprehensive security in the form of multiple men with guns and a single point of entry with metal detectors such as TSA. Other than that, those are not really sensitive places. But that's not the point of today's discussion. The point of today's discussion is Everytown is doing exactly what I had predicted well over a year ago that you were flagged to. And not only did I flag you as to what Everytown was going to do, but I also told you why it would ultimately fail. Specifically, Everytown, if you look at their brief, I'll put a link to it down below and you can check it out for yourself. Everytown is doing exactly what I predicted the anti-gun movement would immediately do, which is to race to the late 19th century to try to justify modern-day gun control laws, because as you know, under Nyserpa versus Bruin and Heller, the way it works is once the text of the Second Amendment is implicated by a modern-day gun control law, the text being the right of the people to keep and bear arms shall not be infringed. Once you have a modern-day gun control law, such as a sensitive place law that says you cannot bring your gun peaceably into that particular location, well, that obviously is hindering your ability to carry a gun into a particular spot. Therefore, that constitutes an infringement, because to infringe means, at the time of the 18th century at least, and even today, but at the time of the 18th century, if you look at the definitions of the sources that the Supreme Court has used for 18th century definitions of words, the word infringement, or to infringe, a verb, means to hinder or to destroy, and obviously if you're restricting my ability to carry a gun into a particular place, you're hindering, you're limiting, it's an obstacle to my ability to exercise my right to keep and bear arms, and therefore the text of the Second Amendment is therefore implicated and triggered. When that happens, you know the process, the drill, which the anti-gunners like to try to hide from, but it's true. The burden shifts to the government. And what does the burden shift to the government to do? Basically, it says the government is going to lose, the Second Amendment is going to prevail, and the modern-day gun control law is going to be struck down as illegal and unconstitutional unless a very narrow set of circumstances arises. Specifically, the government has the burden to show there is a long-standing tradition of a particular kind of gun-related regulation that's been on the books since the time of our founding, and therefore the modern-day gun control law arguably is analogous to that. That is the only way a modern-day gun control law can stand. The classic example I like to give is we all have a right to keep and bear arms. That is a fact, but that does not give us permission to go out and engage and use a firearm to commit cold-blooded murder, using any kind of weapon, including a gun, to commit a cold-blooded first-degree murder is never protected by the Second Amendment, and that is the kind of long-standing restriction on our ability to use a gun that would withstand constitutional scrutiny. That is essentially what the anti-gun movement or the government has to prove. So what I predicted and what is going on here again with the Everytown brief is specifically, if you look at American history at the time of 1791 and the founding era, there were really very few historical gun control laws on the books in any respect. And as a consequence, when the anti-gunners of the gun control movement tries to justify modern-day gun control laws as a matter of historical fact, they don't like to go back to 1791 because when they go back to 1791, there's very, very few gun-related laws on the books, and most of those are really anti-terrorism statutes that say things like you can't take a gun and terrorize people with it. You couldn't walk into a bar and point a loaded gun at people and threaten them. That kind of sort of anti-threatening criminal terrorism behavior is a no-go, and is a no-go today. That's what we're really talking about. That's the only sort of things we see in the late 18th century. So what does the anti-gun movement such as Everytown try to do? Well, we know what the gun control movement does. We know what the state of California likes to do. They don't like to talk about 1791. They like to move to the late 19th century, specifically after the adoption of the 14th Amendment. The 14th Amendment was adopted after the Civil War in 1680. I apologize for that. In 1868, the 14th Amendment is adopted after the Civil War, and that obviously there was two purposes of the adoption of the 14th Amendment after the Civil War. One was to take the original Bill of Rights and expand it to cover the freed African American slaves. So the scope of the 14th Amendment was to expand outwards who was protected by the Bill of Rights and the Constitution. The second thing, and a related thing it did, is expanded the scope of the types of governmental entities that could not violate the Bill of Rights, because in 1791, the Bill of Rights was originally just restricting the conduct of the federal government in 1791. After the Civil War, in 1868, not only does the 14th Amendment allow the Bill of Rights to be expanded to protect the freed African American slaves, it also expands outward to prevent states and local governments in addition to the federal government from being able to infringe upon fundamental rights such as those found in the Bill of Rights. That was the purpose of the 14th Amendment. In response to that, of course, what happened was, in the late 19th century, two things occurred that gave rise to new gun control laws of the sort we did not see in the 18th century in 1791. One is there's an attempt in many parts of the United States to try to come up with gun control related laws that made it harder for the freed African American slaves to be able to keep and bear arms. So there's this great push for gun control law that would really, in the real world, only be applied to African American former slaves and never to the whites. So that was one trend we saw in the late 19th century as to why there's more gun control laws in the late 19th century than we see in 1791. The other trend we see is the expansion of territories. Now, this is key to understand, the expansion of Western territories. Do you hear what I just said? Territories. The reason why that's important is a territory is not a state. A territory is not a state, but you did have an expansion of various territories like, Arizona, Tombstone, blah, blah, blah. The point being, in some of those territories, in some of the towns in those territories, you can see on the books gun control related laws. We don't need to get into that history because the Supreme Court has already said that territories and laws of territories don't speak to the meaning of the Bill of Rights, because the Bill of Rights only applies to the federal government and to state governments, and the local governments has nothing to do with territories, because by definition, territories in the 19th century were not part of the United States, right? They weren't part of the federal government, they weren't part of the local government, they weren't part of the state government yet. The territories were pre-state, and therefore, to the extent they had any laws in the late 19th century that dealt with guns, it doesn't speak to the American tradition. Those were territorial traditions that were completely distinct. That's not just Mark Smith saying it, that's the Supreme Court. So the point being, though, is what the Everytowns of the world and what the anti-gunners of the world like to do is they immediately like to go to the late 19th century and try to argue that those gun control laws in the late 19th century after the Civil War are historical analog laws that can be used to justify a modern-day gun control law today, which is what I predicted. And the reason why this is wrong is because the Supreme Court has repeatedly said that the way to interpret any aspect of the Bill of Rights, including the Second Amendment, is you look at the time it was adopted, ratified, and created. Think about the Bill of Rights. It's a form of a contract. If you and I enter into a written contract today, what you and I understand the words on that written contract to mean, what we understood our deal to be today in 2024 is binding, and that terms of those contracts is the contract. It doesn't change over time. That's the same with the Bill of Rights. So when the Bill of Rights, including the Second Amendment, is adopted in 1791, the meaning of the Founding Fathers when they adopted the Constitution and the Second Amendment in 1791, that's what controls. That is what the Supreme Court has repeatedly said. In fact, if you look at every single Supreme Court case that has examined historical evidence to determine the meaning or the scope of the first 8 provisions of the Bill of Rights, everything from the First Amendment, free speech rights, to the Second Amendment, to the Eighth Amendment, cruel and inhumane punishment clauses, and so on, they always look to they either look entirely at or principally at the founding period, or maybe earlier, to the extent like the Second Amendment adopts a pre-existing right that existed before 1791, but they never look at 1868. The only reason why 1868 and the adoption of the 14th Amendment and that time period can possibly be relevant to the understanding of the 1791 Second Amendment is if the 1868 late 19th century understanding of the Second Amendment confirms or affirms the 1791 understanding, to the extent that the late 19th century laws suggest that the scope of the 1791 Second Amendment should be narrowed or shrunk or reduced in any respect. The Supreme Court has said unequivocally that that is not allowed. If there's any late 19th century laws that are inconsistent with the 1791 text, the text controls, and those laws are to be ignored. We see this over and over and over again. For example, in the First Amendment context several years ago, in a case called Espinoza versus Montana, the United States Supreme Court was interpreting the First Amendment religious clauses that say you can't establish a religion, as well as you have the free exercise of religious choice and religious freedom, and they were interpreting that in a case called Espinoza versus Montana, which dealt with laws that restricted the ability of people to use public funding for their children to go to religious-oriented schools on school voucher programs. And in the late 19th century, and this is very important to understand in the Espinoza case because it's very, very helpful to the Second Amendment movement. In the late 19th century, there were 30 states that had adopted these rules that said public money cannot be used for religious schools. And Chief Justice John Roberts and the Supreme Court in Espinoza said that the 1791 understanding of the First Amendment's religious clauses control, and the fact that you had 30 states, not territories, but 30 states in the late 19th century had adopted these provisions that the court found violated the First Amendment, did not allow, they did not say that because you had 30 states that violated the First Amendment in the late 19th century, that overrides the text of the First Amendment or the 1791 understanding the First Amendment, because it's just too late in time. So obviously by analogy, you can certainly see why the late 19th century laws and even the early 20th century laws relied upon by Everytown in this brief is really irrelevant. And you can see what they're trying to do. They're trying to say that's the relevant time period for interpreting the 1791 document, but that's not true. They're trying to say that the 1868 adoption of the 14th Amendment somehow cuts back on the scope of the Second Amendment, and that is simply not the case. And if you think about it just in a little bit more commonsensically point of view, the Supreme Court has repeatedly said that the scope and meaning of the Second Amendment has the same meaning whether it's applied to the federal government or the state or to the local government. Specifically, what the Supreme Court has said is as follows: we have made clear that individual rights enumerated in the Bill of Rights and made applicable against the states through the 14th Amendment have the same scope as against the federal government. So there you have it. Now, obviously, the only way to understand that is you can't have a situation where the 1791 understand the Second Amendment means one thing and the 1868 understand the Second Amendment means something else. That would be incongruous, and that's not allowed. The other thing, if you just think about it, if you actually go back and look at the history of the 1868 14th Amendment adoption, it's pretty clear that, for example, there was concern about protecting the Second Amendment rights of the freed African-American slaves. There was a lot of discussion and adoption of what's known as the Freeman's Bureau. I probably should do an entire video on the history of the 19th century Freeman's Bureau, which was specifically designed to try to bring the freed African-American slaves up to par, up to speed with all their full-blown rights as citizens. And it was very clear that one of the most important rights they talked about in the Freeman's Bureau to make sure that the freed African-American slaves were brought up to the same level as the white citizens was was to make sure they had the right to keep and bear arms. That was very clear. So obviously the Second Amendment was understood to be very important and a fundamental right at the time of the 14th Amendment, just like in 1791. And the only other point I want to make about this Everytown brief and why I don't think at the end of the day it's going to fly with the court is if you actually look at a lot of their authorities. A lot of their authorities are actually very late, even if you measure it against the adoption of the 14th Amendment in 1868. Specifically, you'll see that they are citing to sources gun control statutes from the 1890s and from the 1900s. So really what you're talking about is extremely late 19th century gun control laws and 20th century gun control laws. And the U.S. Supreme Court has made it clear that 20th century gun control laws are way too late to have any understanding about the 1791 Second Amendment. And again, if you think about it, the 14th Amendment, which is how you incorporate the Second Amendment against the states and localities in 1868 versus laws from 1890s, that's decades between the two. So even if you want to argue that 1868 is somehow relevant, when you get to the 1890s, you're decades and decades and decades after the adoption of the 1868 14th Amendment, and the world has completely changed because in 1868, you're dealing with the aftermath of the Civil War, then you have the Freeman's Bureau and the Reconstruction era, and then once you get to the late 19th century, like in the 1890s, you're well past really the post-bellum Civil War era. You're into a much different world, and I don't know what anyone in 1890 in their views of the Second Amendment or even the 14th Amendment would carry any weight versus the people that were around when it was adopted in 1868. But anyway, none of this matters because the Supreme Court has made it very crystal clear that you understand a constitutional provision at the time it was adopted by the people it was adopted. And if you look, whether it be at the First Amendment context, the Second Amendment context, or any of these other contexts, the United States Supreme Court itself has repeatedly said that the most important time period is the founding era time period. And again, later history may be relevant, but by relevant, it means a one-way ratchet. It can be relevant to the extent it affirms or confirms the 1791 understanding, but to the extent you're using, which Everytown is doing with this brief, late 19th century historical analog laws to undercut or reduce the scope and protections of the 1791 Second Amendment. In that instance, you ignore the later laws because it's not confirming the 1791 understanding, it's contradicting it, and in that case, the text controls. The Supreme Court has repeatedly said this, and I think that that's what the Ninth Circuit will say here as well. All right, folks, hope you learned a little bit something here today about the 14th Amendment and the Second Amendment and the time periods and some of the arguments made in that May versus Bonta case. We'll keep you apprised as things develop. Don't forget to subscribe and resubscribe. We're having issues keeping our subscription numbers up. People seem to be getting unsubscribed. I don't know what's going on, but we're trying to fix that. And feel free to follow me on X at 4Boxes Diner. And we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.